If you're new here, I'm Emily D. Baker, the badass lawyer, host of the Get Legit Law and Shit podcast and legal commentator. I've been a licensed attorney for over 15 years, but I'm not your attorney, not legal advice. I am a big fan of the cursey words, so headphones are recommended. This is where the law nerds unite to break down the news stories that you want to hear about with facts, not fuckery. Y'all, we need some extra lip gloss tonight before we even get into anything. We just law nerds. I feel like this meeting of the law nerds is called to order. We have some new court documents filed in the Tati Westbrook without a crystal ball Katie Joy Paulson lawsuit. So tonight is kind of my first impression going through it. And then I will do a recorded full breakdown because your girl gets distracted by the chat all the time. And I want to talk to y'all. Like, this is our time. Like, the hair is up. This is our time to have a chat about what is going on in all of this. And then I will do like all of the legal breakdown. We're going to do a little bit of that. First, I'm going to just explain what this is, and I'm going to pull up the documents in just a second. Thank you all for coming in. Have fun, chat with each other, be kind, and away we go. I am going to try to keep this at an hour because you know why? Because I am tired. It's been a long day with tech issues and all the things. And I've got my Facts Not Fuckery sweatshirt, t-shirt on. I'm really enjoying it. We're talking about facts this evening. This is a motion to dismiss. It was supposed to be like a bomb. It was supposed to be all the things. It's a motion to dismiss. You guys, I know the chat's rolling super fast. I can see it. It's on a 60-second delay, and that's about the best that I can do. Otherwise, it gets really hard to actually chat. So it's going to be fine. It's just going to be fine. So this is a motion to dismiss. This is super common procedurally. It generally happens at the beginning of a case. This one has a bunch of stuff in it. The problem off the bat for me is that the rule wasn't stated, that the section that this was being filed under. So in the 12B world of like different types of motions, you can do a 12B 1, 2, 3, 4, 5, 6, 7. Normally, here, we don't need this up. We can normally what you do in legal writing is say, the issue is this, the rule is this, and then you talk about it. Issue, rule. Issue, rule. The issue is kind of stated, but the rule is not stated. So I think some of these are coming under 12B6 motion to dismiss, but I think some of them are coming under other sections of 12B. So I think there's also a 12B 2, lack of personal jurisdiction, a 12B3, maybe improper venue, but it's not clear. Maybe a 12B1, lack of subject matter jurisdiction, 12B6, failure to state a claim upon relief, which could be granted, and then failure to join a party. So it's like 12B salad. But the different sections of 12B aren't stated, which just made me tired. So when I was going through it, I'm like, but what section of the rule are we in? Can we just talk about the different sections of 12B? I see all you saying, you are all like, IRAC format. Yeah, we were lacking IRAC format in this, and it made my head hurt a little bit. When we talked about Johnny Depp earlier today, 7 years ago, I talked about the fact that the judge very well parsed and laid out what he was looking at. As a research attorney, if I had read this, I would have just been like, what? No. And I would have gone to my judge and been like, I need you to spell it out. That's your job. So this would have made me a little bit cranky as a research attorney. Nonetheless, Let's get into what it is. A motion to dismiss, standard procedural motion in court, state and federal. There's a number of different statements about this. There are things that you can see that I made my notes. There are things that I had to say about. Once we get into it, I am going to pull up. There was a motion for judicial notice. There's a couple things, and there's also a two declarations that we'll get into kind of towards the end. But I am going to pull up the request for judicial notice because there's a whole bunch of, it's a request for notice of the business partner lawsuit. Told you they're related. The business partner lawsuit, which is this, scroll. And then there's a list of like YouTube stuff. And I want to pull up the different videos. I haven't done it yet. So that's going to be my first reaction of pulling up the videos in this appendix, like what all these different videos are, because there's a bunch of YouTube videos in here, and I want to see, like, there's Breaking My Silence. Thank you for titling it. I want to, like, knowyourmeme.com, memes, events, Carmageddon. Like, I want to know what all this stuff is. So we're going to pull all this up. Like, I think this is the Know Your Meme definition of Carmageddon. Shane's face. Like, what? Carmageddon is a series of controversial events and resurfaced videos leading many to call for the cancellation of Shane Dawson and Jeffree Star in late June 2020 after YouTube beauty gurus suggested that Jeffree Star and Shane Dawson purposely instigated the James Charles Tati Westbrook feud for their own personal gain. So we will get into all of that, but I'm going to pull all of these up link by link because I want to see what they are. And I haven't had a chance to do it yet. So I figured we could all just like learn together. But the introduction goes in that plaintiffs Tatiana and James Westbrook are prominent, notorious social media personalities in what is referred to as the beauty or beauty drama scene, not community, beauty drama scene of YouTube. Here's where I take issue. Is Tati a beauty drama channel? Like, why is Beauty Guru not the thing? I don't understand. Like, why are we not saying beauty guru? Why are we saying beauty drama scene? Why aren't we saying beauty guru community? I'm so confused by the language used. Yes, notorious. Anyway, some of the language in here was just like, oh, okay. They say Dramageddon and Carmageddon in here a lot, which I kind of live for. So I take issue with beauty drama. They're beauty gurus. I mean, and James isn't, Tati is. But they don't really separate James and Tati in this, and they don't address a lot of the claims in the complaint. And I have the plaintiff's documents up so we can look at them if we need to. Like, I was sort of prepared because professional. So it goes on into the fact that since the spring of 2019, much, perhaps most of the attention has been negative on Tati and James. It goes into accusing James Charles and Bi Sister. It gets into that she reignited the controversy when she returned to YouTube in June 2020 to falsely blame two of her other rivals, the prominent social media personalities of Jeffree Star. 2 R's. I thought it was 1 R. Let me know in the chat if I'm right or wrong. I thought it was 1. I was confused. 2 R's and Shane Dawson for coercing her into making earlier defamatory accusations against James. She alleged that Star... Isn't it 1 R? Anyway, she alleged that Star and Dawson engaged in this coercion as part of their far-flung and murderous conspiracy. Y'all, did I miss something? Like, I watched Breaking My Silence. What did I miss? What is the murderous conspiracy? I am dying to know what the far-flung murderous conspiracy is. I need to know. I need someone to tell me. I missed something. But I need to know what the murderous part is. I don't know what I missed. I feel like I'm in Hamilton being like, what did I miss? Like, where did I miss the murderous part of the conspiracy? When did this become true crime? I can get down for true crime. I would like to talk about something other than defamation. What happened? I want to know. Anyway, I feel like I missed something. I very much want to know. And I want to know the murderous part of the conspiracy that Shane Dawson and Jeffree Star and Star 2Rs entered into. Do you guys think Jeffree's like didn't even spell my name right? Like, do you think because I'm sure at some point he watches this stuff. Does it annoy him? Like, I feel like he's bothered. Anyway, I feel like he's bothered. In the second video, Breaking My Silence, Miss Westbrook states was approved by her legal team. She alleges that Star, it wasn't just a typo. It's like 2 R's through the whole thing. I didn't notice that until I was reading it out loud to y'all, but okay. Are responsible for inflicting the severe personal and business injuries she suffered since May of 2019 and warns of coming litigation against them. I know she did. She did. I was kind of wondering. She totally did. So then it talks about the massive criticism that she faced. I think that's generally true. She did. They quote PewDiePie, who is the most famous and widely subscribed to YouTube personality in the world. And are we saying that like PewDiePie is part to blame for the stuff that happened to her channel? Ocean Silhouette is saying Tati mentioned being afraid for her life. That gets into it later, but is that murderous? I don't know. I wouldn't. Maybe it's DA. Maybe it's DA, Emily, that's going like, because I worked in gang prosecutions at times, and there was a very big murder for hire case that went down with a DA I really enjoyed watching in court, and got to watch that case happen. And like, so when murderous plot, I'm like that people accuse the drama community of stretching. They're like, it's a stretch. I don't know. I think murderous is a stretch. I think it's like a good old drama community stretch. I feel like it's a it's a good old drama community stretch on the murderous conspiracy theory. My thoughts. So they get into the videos that are referred to lovingly as Dramageddon 2.0 and Carmageddon. I wanted Dramageddon 1 to get a footnote. That's just me. Dramageddon 1 was an earlier scandal involving other YouTube celebrities. Like, I wanted a footnote with like Dramageddon 1 involved Jeffree Star saying that Manny MUA was a bad friend. Like, I wanted the footnote. But I did say gangs all here with that. The Westbrooks' troubles multiplied in October of this year when their business partner, Clark Swanson, sued them for $5 million in Los Angeles Superior Court. And I think it's damages over $5 million. I don't think $5 million is the amount that they sued for in that case, because the damages weren't, you know what? Let's just pull it up. I forgot to pull it back on screen. Sorry. Sorry. My bad. Let me pull up I just want to pull up Clark Swanson's complaint, because I really don't think he sued for Rachel, this is a point well taken. I don't think he sued for $5 million. That's the one thing I didn't think to pull up. It's attached in here, but I don't want to have to like search it back and forth. As a DA, do y'all actually go and sit in and watch other cases? Yes, we did. Absolutely. Especially as a younger DA, you would go in and sit and watch the more experienced attorneys, particularly in really unique or high profile cases. Sometimes I ended up running AV for some of the Lindsay Lohan cases, amongst other things, with one of the lead prosecutors. But we would go in and watch each other in trial. There were times when we had witness intimidation stuff, or we had stuff related to a potential juror intimidation, where we would go sit in the audience. Because when you're the DA, you're like sitting here and talking to the judge and the jury, and there's a lot of shit that goes on behind you that you just can't see. And so if there were concerns, there was times I would go sit in my colleagues' cases to keep an eye on what was going on. I mean, there was a day in my office when I ended up under my desk because we thought there were going to be shots fired in the hallway because of a fight that broke out in court. And all of the deputies in the hallway were screaming, "Guns out, get down, get down." And we're like, under the desk. It's DA stories. Don't make it a drinking game, y'all, because it's going to be dangerous. Okay, I need the business partner lawsuit. Yes, it's attached, but I want to have it in a separate window. I didn't think I'd be pulling this up, but I really don't think it's for $5 million. I just don't. There should be a beauty guru version of the game of Clue. I feel like it's like it was Clark Swanson in the DMs. Okay, let's talk about the demand. I've pulled up on the screen the business partner lawsuit. You know the one. This is a lawsuit caused by the defendant's greed. That one. I'm going to scroll all the way to the end because that's where the prayer for relief is. And I didn't see a specific amount. I only saw jurisdictional amounts. Prayer for relief. Plaintiffs seek money damages against all defendants on all counts for which such damages may be received, punitive damages, injunctive and equitable relief. Y'all. It's a jurisdictional amount that they put in here. It's not a suit for $5 million. I'm so confused as to why that's in here because the jurisdiction says why the court may enter jurisdiction. They don't even have the amount in the jurisdictional claim. Okay, y'all love it when we're going to control F and look for 5. Where is it? Oh, all the fucking phone numbers. Of course it is. Let's look for million. Technical difficulties. Which one is this? What happened? The Westbrooks made millions of dollars. The value of the company was $250 million. Celebrities with millions of followers had been offered. Jeffree Star had been offered. Star's 2 R's in here too, by the way. So no shade. Star's referred to by 2 R's in this lawsuit as well. Have we uncovered something? I don't know. T. Over $1 million. Yeah, it doesn't say anywhere in here. And I have a pretty decent memory sometimes for the things I read. And every now and then I'll be like, I don't think it said that. My husband hates that when we fight because I'm like, but this. And he's like, no, it's this. And I'm like, I remember things. So I've switched back to the defamation lawsuit motion to dismiss. Again, it says that there was that $5 million claim. And it just wasn't. Anyway, the Westbrooks' troubles multiplied in October of this year when their business partner sued them for $5 million. It bugs me so much that it's in here. I don't know why, because that's not what's in the prayer for relief. Perhaps most injurious to plaintiff's reputation was Swanson's sworn accusation that Miss Westbrook boasted of her ability to use her celebrity to sell a shit product. I will just say that came well after the statements alleged in this complaint, but either way. That lawsuit, the filing of which was first reported by defendants Catherine Paulson and her corporation Without a Crystal Ball, also received wide coverage in both social and mainstream media. Like 4 times. It says that she broke that lawsuit like 4 times. You guys, she was the first one that reported the lawsuit. Give her credit. It is in this lawsuit. It is in this motion to dismiss at least 4 times. At least 4 times. It needs to be very clear. The thing is, though, her breaking of the lawsuit doesn't have anything to do with the complaint that they're trying to dismiss. It's in here, but it has nothing to do, I don't think, with the complaint they're trying to dismiss. Because the complaint they're trying to dismiss is for the videos and the statements that were made after the videos. And most of those videos were made before that last video where she broke the story. Some of it's in there, but her covering that lawsuit isn't the problem that's being alleged in the defamation suit. Her assumptions stated as fact is what they're complaining about. So I don't understand why the motion to dismiss part isn't talking about the complaint, because generally in a 12b6, you're like, but they pled this wrong. So I think this is trying to go to the fact that the damages are caused by Jeffrey and Shane. I think that's the point. So we'll see. Just days after the defendants broke the story, there it is again. Days after they broke the story, plaintiffs filed this lawsuit against them in Seattle. Presumably not by mere coincidence. That word looks wrong to me, but I'm also dyslexic, so I don't. Anyway, they sued defendants for exactly the same amount as Mr. Swanson sued them, $5 million. Y'all, if I hear one more person tell me, I forgot to pull it up again. If I hear one more person tell me that this lawsuit, the defamation suit, is a $5 million lawsuit, I am going to lose my mind. So presumably not by mere coincidence, they sued defendants for exactly the same amount that Mr. Swanson sued them, $5 million. Okay, but I'm going back to the prayer for relief. I've switched to the complaint in the defamation case, and the prayer for relief in this case, again, does not say $5 million. The prayer for relief says judgment at a sum to be proven at trial. Maybe I'm picky. Am I picky? Maybe I'm just picky. It's possible. The only time we mention 5 million and it's not 5 million, it's more than 5 million, is to establish the unlimited jurisdiction for federal court. And we talked about this in like 4 videos. Plaintiffs allege that their damages exceed $5 million, exclusive of interest and costs. Thus, the matter in controversy exceeds the jurisdictional minimum. It's jurisdictional. No, Tati didn't sue without a crystal ball for 5 million. It says that the damages can exceed 5 million and that puts it in the different track of court and that the amount is to be proven at trial. That's it. That's all. I am bleh. Jesse, it's just okay. Let's just keep going. Let's just keep going. I'm going to pull this back up. Okay. We're switching back to the motion to dismiss. I'm going to take off this because I feel like it's blocking part of the screen. Hold on. I tried to make the banners small and then we're just going to take it off and just leave. We know who I am. No, I should leave it because then when people use my stuff, I'm going to leave it. So when people use my stuff, they at least know who I am. Okay. Until I get clipped out entirely. All right. So that's where we're at. The 5 million. I don't know why it bothers me so much. Call me picky. It totally bothers me. They allege that defendants are responsible for the severe personal and business injuries they have suffered during the period of Dramageddon 2 and Carmageddon. The only reason I take issue with that is because I hate switching back and forth on y'all, but the videos alleged, I switched back to the complaint. The videos alleged go from May 11th, 2019 and October 29th, 2020. So I think Dramageddon was over by then and maybe it overlapped with Carmageddon, but I don't think it's the whole thing. Okay, switching back to this. They go on in their kind of introduction statement to talk about putting aside the patent silliness of plaintiffs' attempt to blame a small YouTube channel located in Hanover, Minnesota for their injuries. The complaint should be dismissed now for several reasons. Rule number 1. No. First, plaintiffs have come nowhere close to establishing that this course may exercise personal jurisdiction. So we've got a personal jurisdiction mode that have zero relevant contacts with Washington State. I had a question about that, but we'll see. Second, the plaintiff's decision to name 100 Doe defendants, which isn't weird, precludes this court's exercise of diversity jurisdiction. And I haven't read the cases on that, but I feel like I'm just like, you can allege Does and still have diversity jurisdiction because it means that everybody's in a different place Third, plaintiffs have failed to include necessary and indispensable defendants, including Starr and Dawson. I think they're trying to argue joint and several liability, which doesn't apply in defamation generally, because here's the thing, like, I can say something about somebody, but then somebody else can say something about them. And both of those things can be defamation if you show damages. And while I've said damages can be hard to prove, it doesn't mean joint and several liability apply to defamation. But I think that's the argument there. Fourth, plaintiff's claim of Consumer Protection Act. We're not even getting into the Consumer Protection Act stuff tonight. We'll get into it in the full legal breakdown. So they are essentially asking, and I see the scroll going. They're essentially arguing that this case has to be dismissed unless you also sue Shane Dawson and Jeffree Star, because they also did shit, and the shit they did caused damage. But it's a defamation suit, and so joint and several liability, like if Jeffree Star and Shane Dawson caused harm to Tati Westbrook based on the things that she said in Breaking My Silence, it doesn't excuse or reduce liability for the 40 videos that are listed in the complaint here. So I'm confused that we're not focusing on the complaint here a bit. So I mean, this is why we do the full legal breakdown tomorrow, because I'm just like, I need to sleep on it. Oh, look, we have Jeffree Star with one R. I didn't realize that in the Clark Swanson lawsuit, they also spelled Jeffree Star with two R's, and that in Salty's suit, they spelled Jeffree Star with one R. I'm interested in that coincidence. So the statement of facts. Ms. Westbrook falsely accuses a young rival of sexual misconduct as an audience of more than 47 million. So we talk about Bi Sister and why Bi Sister sucks, and that Bi Sister, NBC News reported Bi Sister was viewed more than 35 million times. I think we think it was viewed more than that, don't we? I think it's 1R too. I saw the chat going, it's 1R. I think it's 1R. There's a lot of correlation between the lawsuits. I keep saying that. It's weird. So this talks about Bi Sister and Dramageddon drawing attention. This talks about Miss Westbrook tearfully blaming two other rivals for her false accusations against James Charles to an audience of more than 12.5 million. Okay. Yes. I'm trying not to be petty with the typos. I'm not commenting because I don't see them. I am not commenting because it is not helpful for our recitation of this. So I'm trying. I'm trying. Okay. We talk about breaking my silence and why breaking my silence can cause harm. And here's the thing. Breaking my silence can cause harm. Breaking my silence can also have caused harm, but that doesn't negate the harm that can be caused by what they alleged in this complaint. So I think talking about, well, this caused all the harm and ours didn't, that's what litigating the suit is for. That's not really what a motion to dismiss is for. Generally, a motion to dismiss is like, you didn't even allege something that I can fix in court. Like, you didn't even state a cause of action. It's for like, this shit's so bad, it's got to go. And then jurisdiction stuff. I wouldn't have been surprised if we just saw a jurisdiction movement or jurisdiction motion or a motion to quash saying, look, we don't have jurisdiction here, instead of trying to put all of this into the motion to dismiss, because this isn't going directly to the complaint. So I would have expected really a tough attack on the jurisdictional component. That's what I would have expected. So it reminds me, because I know that Salty's going to have to respond to this, but it reminds me of that scene in Clueless where it's like, but Miss Guys, or no, it wasn't. It was the other teacher. I can't even respond to that. She's talking about a garden party. How can I do my assignment if she didn't do hers? Like, when I'm trying to think of how to respond to this, I'm just like, right, but right. Okay. 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 So it gets into Bye Sister, it gets into Breaking My Silence. It talks about that. We get a shout out to Trisha Paytas in here. We get a shout out to Trisha Paytas because in another popular YouTube commentator named Trisha Paytas posted a video entitled "Tati is Dumb as Hell," which drew 2.5 million direct views, in which she lambasted Miss Westbrook for falsely accusing James Charles and trying to dodge responsibility by showing that others made her do it. So we also talk about PewDiePie again. The backlash soon went global. PewDiePie posted a heated commentary on Breaking My Silence, criticizing Miss Westbrook for her unbelievable manipulation, refusal to take responsibility, and blame shifting with respect to Bye Sister, saying Miss Westbrook has quit YouTube because this is so embarrassing. Okay, but what about your 40 videos? Okay. So then the Westbrooks sue defendants and no one else in Seattle for harm they previously claimed was caused by Starr Dawson and their Los Angeles-based conspiracy. Again, defendants were first to report on the Swanson lawsuit after it was filed. Defendants were first to report on the Swanson lawsuit after it was filed. Are we on 3 or 4? I think it's the third time. It might be the fourth time. And then what followed was widespread media coverage of Swanson's claims, in particular the fraud allegations and the evidence of Miss Westbrook's cynical contempt for her consumers or customers and fans. And then it talks about all of the other headlines with regard to reporting on the business partner case. Just days after defendants broke the story, 5? Is it 5? Is it 5? I think that's 5. Just days after defendants broke the story of Swanson's $5 million suit, you know how I feel about that claim, seeking to deflect attention from those allegations, and that $5 million claim brought this lawsuit ostensibly seeking $5 million for injuries they allegedly suffered during Dramageddon 2 and Carmageddon, but they did not bring their claims against Starr, 2Rs, or Dawson. Instead, they only sued Ms. Paulson and her small, solely owned LLC, both Minnesota residents. The complaint makes no mentions of the Westbrooks' very public allegations that then wildly famous and influential Starr and Dawson and their Los Angeles-based conspiracy caused the Westbrooks' Los Angeles-based injuries. Instead, they now allege that defendants from Minnesota with their 135,000 subscribers caused their severe emotional, physical, reputational, and business injuries because of their reporting related to the two scandals. That's not the point, though. The point's not the reporting. The point is the statements that were extrapolated from the reporting and stated as fact. That's the point. Also, didn't she have more subs on than 135,000? I thought she had more subs than that. Just point of concern. My note was they're alleging more than that because that doesn't really accurately state, in my opinion, it doesn't really accurately state the allegations. So, okay. Let's keep going. The argument, the applicable standards and burden shifting. The thing is, it still doesn't say what motion we're bringing. Are we in 12B6? Are we in 12B2? Like, what motion are we bringing for this part? I know we're talking about long arm statutes, but what part? Anyway, This gets into the jurisdictional element, which is arguing, and I will get to the other stuff because I'm going to break down the jurisdictional stuff in the legal breakdown of this. The jurisdictional stuff is saying, you can't bring this lawsuit here, go bring it somewhere else. That's it. That's it. Amber, here's the best I can figure from reading this. The best I can figure from reading this is that the theory that is being worked with is that this lawsuit was brought because she broke the story. But the lawsuit was brought over statements made in this complaint over these 40 videos. Most importantly, the Pathos article, which is mentioned the most in this complaint, the Pathos article being back from, I don't know which year the Pathos articles was. It's in here somewhere, but the Pathos article is one of the ones that's talked about the most. So it's not just the breaking the story. There are 40 videos listed and statements from those videos listed in the complaint. So just talking about the fact that she broke the story doesn't make a ton of sense to me either. But moving on. This is all jurisdictional stuff saying, go file it. You shouldn't have filed it here. Here's the thing, though. If your case gets dismissed for jurisdictional grounds, but the diversity jurisdiction point is well taken here, but if it got dismissed arguendo on jurisdictional grounds, it can just be filed elsewhere. So it doesn't really make it go away. It could make it go to another venue. So he's basically saying that Katie's just a small town girl. So my question now is, does she also live in a lonely world? It's a well taken question. And I appreciate that. That's funny. Question, when will the judge look at and respond to this, before the scheduled court date or on that date? Kylie, that's a fantastic question. This was noticed for December 28th. I don't know what day of the week it is. I think this federal court hears stuff on Fridays, but no, the motion to not this, I didn't even bring it up because I wanted to get into this, but the motion regarding the preservation of evidence is still noticed for December 18th, and they're still pending an answer on that. So an answer should be coming pretty soon with regard to that motion, because that motion will be first, and then this will come up. This is noticed for December 28th. So there's still so much left. There's still so much left in 2020. So this goes into some of the legal standards with regard to jurisdiction, but it doesn't get into what section they're bringing this under, because we're bringing it under this section. So this stuff matters once we get past the first step. The first step is missing for me. So that's research I'm going to pull up and then do it, because it's looking at 12B 2 and 3 is something I have not done since law school. So we will get into that in the full legal breakdown. The complaint contains no allegations even suggesting this court may exercise personal jurisdiction with respect to plaintiff's Halo's claims. Because remember, Halo is suing both defendants. Tati is suing both defendants. James is suing both defendants. So they're arguing that the business can't sue, but if there's diversity jurisdiction found with regards to the owners of the business, I believe that they still can sue on behalf of the business there, because everything's inextricably linked. So the jurisdiction over Tati and James in Washington becomes kind of the point of this, because they're all together, and Tati and James own Halo through another business that I believe is jurisdictioned in Washington. So the allegations of the complaint, even taken as true, do not establish personal jurisdiction with respect to the Westbrook's claims. It goes into why it doesn't, that the defendant's actions were not expressly aimed. They didn't aim their conduct. I think this is at Washington State, as Washington State. And that the jurisdictional argument here is really that Tati and James were living in Washington when the defamation happened, because it happened online. Where they live is a proper place to file. This is arguing they didn't live there, so it's not a proper place to file. So you can see me trying to figure out. I'm like, is it jurisdiction or is it 12b6? Is it what are we going in for? Um, and then this gets into when they moved to Washington. Plaintiffs allege that defendants knew plaintiffs had moved to Washington in 2018, and here's why. There is a statement about Tati moving in the complaint. Where is it? See, there's so much about Washington in this complaint. Here, how moved is going to come up just as much. Okay. Here we go. So I have switched back to the complaint because that's what we're trying to address here is the motion to dismiss this complaint. Upon information and belief, defendants recklessly made these false statements without any supporting information. To begin with, it's mathematically impossible to liquidate. In addition, Tati and James moved to the state of Washington in 2018 and became residents therein in 2019, a fact known by defendants as Paulson has made mention of Tati's move to Washington in certain of her videos. They're saying that's not specifically pled enough. Despite having such knowledge, defendants insisted to claim that Tati and James were selling a house they no longer lived in for nefarious purposes. My note on this was, I thought Tati had moved then, but we didn't really know because she didn't make that public. So the statement by Paulson was that they're selling their house to abscond. It was something like that. They're selling their house to get away from responsibility was the claims that were being made in this allegation in the underlying defamation suit. They are saying that no, Tati in fact did move. I imagine that there will be, proof that they paid taxes in Washington. So let's get into that. Let's get back to the other suit, back to the motion to dismiss. They're saying it's not specifically pled enough that she mentioned that they moved for nefarious purposes, knowing that they moved. But if she moved in 2019, I hate to keep switching back and forth on you guys. If she moved in 2019 and these videos were made in 2018, 2019, or 2019, 2020, then allegations were made after they moved. So if allegations were made after they moved, there can be jurisdiction there. They're alleging it's not pled specifically enough. Legal breakdown incoming on all of that stuff on federal subject matter and personal jurisdiction. So what I thought was interesting in this part is that further plaintiff's failure to identify any specific statement by defendants in any specific video made is notable. They had access to these videos at the time they filed the complaint. Sorry, they had access. They had access. Not they have access to these videos. They had access to the videos. Is that an acknowledgement that the videos are no longer accessible? They said had, not have. Words have meanings. Did they really say had? They had access to these videos at the time they filed the complaint. Does that acknowledge that they no longer have access to the video by KJ? I don't know. I want to know what you said. If any specific video included a specific statement establishing defendants knew of Miss Westbrook's residency in the state of Washington at the time of the complaint, presumably they would have identified that in the pleading. But there's a statement in the complaint that she said that they were selling their house to escape business liability. So also in her declaration, she talks about this. In her declaration, she talks about the fact that they moved. So moving on, this gets more into the legal breakdown of if there's jurisdiction, if there's not jurisdiction. And this gets into the elements, the something more. It's this stuff. The something more requirement may be satisfied in defamation cases where, for example, one, the defendant developed the defamatory story using sources from within the form. Y'all, I need you to tell me, didn't she say she was looking for Tati's birth certificate and videos? Because Tati has said she was born in Washington. Like, Tati has said her family's from Washington. She's from Washington. So wouldn't she have been looking in Washington records from Washington? Like, didn't she say she was looking for Tati's birth certificate? And if she said she was looking for Tati's birth certificate, wouldn't she have had to look for Tati's birth certificate in the state of Washington where Tati Westbrook was born? Make it make sense. So they're saying that the something more requirement to jurisdiction may be satisfied in defamation cases where, for example, the defendant developed the defamatory story using sources from within the form. So I said birth certificate because I think that you would have to look at least through state records, even online, you would be looking for them. So if she found them or if she didn't, oh, you guys are great in the chat. I saw a comment. They're going really fast. I know there's like 5,000 people in here, so I'm sorry, but it's going really fast. Somebody said the birth certificate video is in a Reddit thread. Thank you for posting that. So there we go. I thought so. Like, I remembered that. That's why I come on and chat with y'all, because we're crowdsourcing information, all of us. Like, I'll bring the legal, y'all bring the background, the context. The birth certificate video is in the Reddit forum. So if she said she couldn't find anything, she was still looking for it, and she would have needed to look in the state where she was born. This is the video. Thank you guys for reminding me. The video where she said her name is just whatever from Seattle. Her name is just this. Her name is just that from Seattle. That would have had to come from records in Washington. So by this, the defendant developed the defamatory story using sources from within the form. I'm just saying. The story focused on the plaintiff's activities within the form. At least one of the stories focused on the fact that she was moving to like evade liability or responsibility. The defamatory article had its widest circulation in the forum, probably doesn't apply. The article was targeted specifically at an audience in the forum, also probably doesn't apply because YouTube just goes all the places. So, their allegations, they go on to say their allegations demonstrate that defendants found sources for their allegedly defamatory publications from court records in California and Hawaii. Well, not all of them. True, absolutely true, but there's more. But wait, there's more. There's no allegation of targeting a Washington audience. Yeah, I don't think that prong plays. I'm still trying to figure out if we're in which area of 12B we're in. Plaintiffs fail to allege they suffered the brunt of harm here. I'm not sure exactly what part of 12. Are we back in 12B6 or are we still in jurisdiction? I'm not sure where the brunt of harm falls in. The only allegations arguably touching on this requirement are those discussed above, that the Westbrooks moved to Washington in 2018 and became permanent residents in 2019, and that defendants mentioned the move at some point on or before, it doesn't say on or before, it should say on or before, at some point before October 30th, 2020. I think that's still going to jurisdiction, but I can't figure out why. The allegations of the complaint are contradicted by the Westbrooks' own public statements regarding their state of residence. Okay. They're saying that they didn't move, and they're saying these allegations are certainly false, but I'm not sure what allegations we're talking about are false. All of the allegations of the complaint are contradicted because, like, all of the allegations about the 40 videos, about these 40 videos, all of these allegations are negated to be thrown out because they didn't live in Washington or because they moved to Washington in 2019. I honestly, I'm going to have to read it again, but I was having a hard time figuring out what this argument is going to. They say that having established domicile in California for years leading up to 2018, the Westbrooks are presumed to have continued to be domiciled there unless and until they provide evidence that Washington became their new domicile. Does anyone not believe that Tati moved to Washington? Like, aren't they just going to show that she filed taxes in Washington? Right? Like, they'll just be like, yeah, but here's her taxes saying that she lives in Washington. I just think it's interesting that this is the crux of the jurisdictional component, because a change in domicile requires a physical presence at the new location, intention to remain there indefinitely, and you can show that through things like vehicle registration, property, voting, and payment of taxes. Okay, we'll see if that happens. There will be a response from Saltsy, but I thought taxes were mentioned. I made a note. I thought taxes were mentioned in the plaintiff's. Let's see. We're going to use our favorite Control F feature. Okay, taxes. Nope. Might be mentioned in the motion to not delete stuff, because there's a lot of motions in this. They then went to, according to Zillow, the Westbrooks did not list their Los Angeles home for sale until September 2020. Look, I'll tell you what. We moved in the summer. I wish we had listed our home in September, because the numbers in September in Los Angeles were way better than the numbers over the summer, where there were COVID lockdowns and civil unrest and riots and burning of places in Beverly Hills, et cetera, et cetera. When you list the house doesn't mean they didn't move. Do we think that Tati and James maybe own more than one property? I don't know. Maybe. So they're saying they never moved. And then they're listing out social media evidence that they didn't move. And we'll go to the pictures of that and show the social media evidence of what she said. And we'll talk about that real quick. That's in the statements down below. But in this one, they pointed out one where Tati said in her June 30th, 2020 Breaking My Silence video that in the fall of 2019, she became so afraid to stay in her LA home that she made a lot of videos and then left town in October. But wasn't that October 2019? And if she left town in October 2019, doesn't that indicate that she lived in Washington in October 2019? And if so, then all the stuff after that point would have been when she lived in Washington. So that's enough to pull jurisdiction, in my opinion. Okay. Okay. So this is all going through, as I'm waving at the screen because I forgot to pull it up again. This is all going through the social media posts. And we'll pull up the actual posts because they're in a declaration. The complaint must be dismissed for lack of diversity jurisdiction, meaning people don't live in different places. So saying that there's no jurisdiction over Tati and James in Seattle means that Seattle's not the proper venue. But we'll get more into diversity jurisdiction, but it goes back to jurisdiction and venue. Plaintiffs failed to join necessary parties. I don't know which 12B they're bringing in Rule 19 under, because I don't remember off the top of my head, but we'll get there. It's saying that essentially without Jeffree Star and Shane Dawson also being sued, that Tati can't be completely whole. Like, she can't fix the whole harm unless Jeffree Star and Shane Dawson are in this. So you could see that in a case like construction this happens in. It's like if something goes really fucking wrong with a house and you sue the window guy, but not the contractor. The window guy can be like, right, but the contractor is also a necessary part of this, because without that person or the architect or the engineer, you can't be made whole for this particular injury because it wasn't just me. You can also see that in a car accident where you have a car hit by multiple vehicles, saying you can't have full recovery because you were hit by multiple vehicles. So the injuries weren't just me hitting you, it was them hitting you. But it's a defamation case. But it's a defamation case. So it's a defamation case. In a defamation case, the harm needs to be proven, but it's not something that can be, oh, this harm can't be proven because other harm happened. It's like that harm can happen and this harm can happen. And it's the plaintiff's duty. I don't want to forget to pull that back up, but it's the plaintiff's duty to show the harm that goes to the thing. So it's the plaintiff's duty to show what harm was caused. And was it D'Angelo Wallace that was talking about the money that Halo made and that Tati Beauty made after Bye Sister? And I think it was in his video that it was like, this is kind of gross, like Bye Sister happened and then a lot of money was made. So I think tagging money damages to Bye Sister isn't going to work. I think it would have to be the proof of how do we do this. And I think there's enough comments that like, I stopped buying Halo because of statements that KJ made, that they will bring all those things in. So, okay, let's go back. It'll be very interesting. So joint and several liability, again, first thoughts, doesn't apply. Like I will need to go again and look, but under Rule 19, it doesn't apply to defamation because joint and several liability with defamation doesn't make sense because like you said, the statement you said. Okay. The complaint fails to state a claim for intentional infliction of emotional distress. This is getting into the more 12B stuff, saying on its face, and often 12B6 motions don't pass, but saying on its face, you didn't plead enough to sustain this claim, but they didn't put in the rule that the judge has to determine on. So this is just the basic, like it absolutely cannot stand. They fail to prove extreme and outrageous conduct. So this is like, oh, these things, but they're only pulling some of the statements. Because in a 12B6, you assume, in a 12B6 motion, you assume everything in the complaint is true. And you go, okay, arguing everything in the complaint is true, it still doesn't get you there. So even if every single thing you've said is true, it still doesn't get you there. And that's not what's in this motion because they left out a whole bunch of the alleged statements. Like they talked about liar, manipulative, snake oil, junk vitamins, is not necessarily following the rules as a con artist, but there was more. So I think that the fact that not all of the allegations in the complaint were proved here will be problematic. The Westbrooks failed to adequately allege severe emotional distress. Also, this is a fair point because Tati did say that the distress caused from Shane and Jeffrey was similar to the distress caused here. So then alleging that the distress caused by them was different than the distress caused here, I think is a trial issue though. I don't think it's not enough like on its face. Because again, this is like assuming it's all true. This doesn't get you there. I think that's a trial issue that essentially a jury's going to have to say, okay, is it this or is it that? And they're going to look at what KJ said. They're going to look at some of the videos and they're going to look at Tati's testimony at that point. But I think that's a triable issue. I don't think it's obviously there's not enough here issue. The complaint fails to state a claim for negligent infliction of emotional distress. But this again goes to Tati only, but there's also claims with regard to James. So the complaint under the Washington Consumer Protection Act, I'll get into in the legal breakdown. I'll get into it in the legal breakdown. Same with the civil harassment under RCW 1014, because it's more of a procedural, but I think it's a triable issue. They're arguing there that the claims made by KJ are not directed at the Westbrooks. They're just about the Westbrooks. I think, though, that the claims were not the only thing in that, but without going back and forth, I'm not going to pull it up. Okay. Request for judicial notice. The request for judicial notice is asking the court to take notice of the fact that other things exist. All right. So first they're asking to take notice of the fact in the matter of, well, that's not the, I don't know. Sorry, I don't know why the UBs italicized it, threw me off. Swanson versus Halo Beauty. So that is the business partner suit. And a court can absolutely say, yes, I take notice that this exists. It's not that they're going to take notice that the things in it are true. It's the existence of the thing, not the contents of the thing. But then they asked to take notice of the fact that videos and their contents are available to the public on the internet. But you can't take judicial notice of the contents of a video because they're not verified statements. The existence, yes, but the mere existence of them, no. I saw 2 questions come up. I'm trying to get to these, and I'm sorry I'm not getting to all of them. Could this poorly written response rile the judge? I think there will be some questions about why the rule's not stated, because you issue rule, issue rule. And when it's hard for me to parse, it's going to be frustrating for a judge to parse, I would think. Just said, why does KJ's attorney make such a big deal about her and her business not being in Washington? Does it matter where Tati files? It can matter where somebody files. First, it can be inconvenient for them, of course, to have to go to Washington to defend a claim. There can be different causes of action and different defenses in different jurisdictions. So they might have a strategic reason for wanting it in a different jurisdiction and wanting this to be filed elsewhere. Tati and James are like, we live here. This happened on the internet. We have jurisdiction here. We want to file here. They might be seeking to file it somewhere else. But if they are, why would they do that? If they are trying to get them to file in Los Angeles, it might be because California has a very strong anti-SLAPP suit, but that wouldn't really apply in a defamation case. So it might be that they want it to be in a venue where they have different options for civil defenses. So it's a strategic issue. When we talked about the Johnny Depp case, I talked about the fact that the Johnny Depp versus Amber Heard case was filed in Virginia because Amber Heard published it through the Washington Post, and the Washington Post has printing presses in the state of Virginia, though Johnny Depp and Amber Heard both live in California. And it was an online article. And Virginia's like, that's enough. That's the fact that the Washington Post has printing presses in Virginia is enough for you to file it in Virginia. So there was a motion to dismiss there that was denied based on the fact that the printing presses for the Washington Post were located in the state of Virginia. Okay. So you can't take judicial notice of the contents of the video, but I want to go pull up some of these and see what they attached after we get to, no, we'll do that first, and then we'll get to the declarations. So this is what they're asking to take judicial notice of. It is a list of YouTube videos, news articles, a Bing search. I'm very curious as to what the Bing search is. And we're going to see. Okay, so let's just see. We're going to see together because I haven't seen yet what they're bringing into court asking for judicial notice. Oh, Bye Sister is archived. Wait, this isn't Bye Sister. It says Bye Sister. Okay, maybe it's a compilation. Oh, there's Bye Sister. Okay, so this is an archived version of Bye Sister. So if anybody wants an archived version of Bye Sister, I guess that's where it is. Hold on, that's not what I was trying to do. This. Okay, so this is an archived version of Bye Sister. All right, let's see what else is in here. NBC News article, canceling James Charles beauty YouTuber loses 3 million subs. So we know that's an article. Bing. What is the Bing search? This is a search regarding No More Lies, I guess. It looks like. What did CNN say? Did CNN talk about Bye Sister? I mean, everybody did. James Charles brings out the receipts. Oh, okay, CNN Entertainment, we see you. James Charles brings out the receipts in his latest video on the Tati Westbrook feud. So we're, okay, Bye Sister, related to Bye Sister, related to Bye Sister, related to Bye Sister. Newsweek. YouTuber PewDiePie doesn't get the backlash against James Charles. I don't think what Tati did was justified. Okay, thank you. Cool. So that's a Newsweek piece. Whose is this? Is this PewDiePie? James Charles is... Yes! PewDiePie. There we go. Okay. PewDiePie. There had to be a PewDiePie video in there. They mentioned it enough. Let's see whose this is.
So last year there was
D'Angelo.
The target was James Charles.
There we go.
Fast forward to today, and that
I think he talked about the money in this one. I really like his videos a lot, you guys. I really do. Okay, so D'Angelo was this one. There's a BuzzFeed News. There's no one to root for in the James Charles beauty YouTuber drama. This is all about Sister. On the thinly veiled homophobia in Tati Westbrook's James Charles video. I mean, we're not trying Tati Westbrook for Sister. It's going to come up, but it doesn't dismiss the case. I guess I'm just confused. 1 year after beauty YouTuber war burned their community to the ground. Oh, those are strong words. New battle lines have been drawn between the growing stars that started it all. Oh, this is getting into Carmageddon. Okay, great. Insider. And then this is Breaking My Silence. And this is the Know Your Meme with Shane Dawson's face that we pulled up. Oh, this one got deleted, didn't it?
This is insane. This woman is a fucking, oh my God. Oh my.
This got deleted, I think, but this was Shane reacting.
I'm going to wait till as many people get in here as possible because I'm losing my mind.
Yes. Okay. That was Shane being mad about Breaking My Silence. None of this is related to the complaint. Oh, Keem. Hi, Keem. PewDiePie rant on Tati leaked video. I'm kind of surprised just because we know KJ is salty at Keem. I'm just kind of surprised it's in here. I'm just going to say I'm surprised it's in here. But it is. All right. That was this one. Let's see. There's 2 more left. Who else? Who else is in here? Who else is in here? Whose video is it going to be? Trish! What up? Of course it is. I should have known when they mentioned it earlier. I think they put at id, so it had to be in here somewhere. So of course this is in here. But like, do they want the court to take judicial notice of the fact that Trisha Paytas thinks that Tati Westbrook is dumb as hell? Because that's what's in this video. Like, you can't take judicial notice of the fact that Trisha Paytas thinks Tati Westbrook is dumb as hell. I think they just want to pull all the YouTubers into this. It's just like, ooh, let's get all the YouTubers in here. I want everybody. I want everyone. It doesn't go. And Breaking My Silence. Okay. Well, yes, we've all seen Breaking My Silence. But I thought, was that up here? Breaking My Silence is listed twice? No, I thought Breaking My Silence is here. Why is it listed twice? Same video. Okay. Is a judge going to watch all of these? Like, no. What they're going to do is say, I can't take judicial notice of the fact that there's contents of a video. Those people have to come in as witnesses. Like, you have to bring Trisha Paytas in as a witness to say, do you think that Tati Westbrook is dumb as hell? But even then, it still has to be relevant to the case. And at this point, relevance feels like a bit of a stretch. So let me close all these tabs and go back to there are sworn affidavits. We're going to pull up the affidavits. I'm going to answer a few questions and then I'm going to pop off because then it is time to put my little guy to bed. So let's get to these affidavits real quick. There are sworn affidavits. It's just the thing with most motions to dismiss is they go directly to the claims that are in the thing. And the jurisdictional stuff has nothing to do. I'm going to scroll past the business lawsuit. The jurisdictional stuff has nothing to do with it. It's like they're trying to argue damages and that there can't be damages. But if you're going to argue there can't be damages, and I've said this whole case, damages will be the harder thing to prove in any defamation case. But if you're going to argue like they can, as a matter of law, they cannot prove damages in this case, then you file a motion for summary judgment and like litigate that point. I just don't understand why this was chosen to be done this way. And I don't understand why they're not citing which part of 12B that this is going to. I'm confused. Okay, that's the appendix. This is the declaration of the attorney And in his declaration, he says that he accessed these tweets referenced below using his Twitter account, December 1st, 2020, screenshot from Zillow showing the Westbrooks purchased their Sherman Oaks home in California, May 2020, and sold it in September 2020. And then it shows the sale in, or the property sold in May for $3.3 million, and then sold again for $3.8 million, which is a pretty big bump and not a lot of time for real estate. I'm just saying. But I don't know if Zillow is dispositive to prove that they don't live in Washington, because, I mean, they're celebrities that probably own houses, maybe more than one. Just saying. Below is a true and correct copy of August 18th, 2019 tweet posted on the account Glam Life Guru saying, back in LA, excited to get home and snuggle with Puka. I don't know. I think the argument there is, look, she says it's home in LA, but also I think during this time, Tati was on the low about the fact that she moved. And I imagine that her attorneys, when they respond to this, will just be like, it's this. These are more pictures saying, I'm November 7th, 2019, I'm out of town with family, or I'd be there. The argument above was like, why would she say she's out of town? And why wouldn't she just say that she lived there? And then there's more of like, look, she said, just had a major first, landed at SeaTac Airport, and I hear, Tati, I'm wearing your palette. Okay, so she traveled to SeaTac. And in December 2019, she said, ready for the next chapter. So even if she moved in 2019, some of those videos were posted after that. And it's just more of like, there's no place like home, Seattle, I'm back and I'm here to stay. This looks like it's from December 2019. But even if we just assume it was this, everything after this still happened when she lived in Seattle. And I really think that the searching for records regarding Tati and her name would have had to happen in the state of Washington. So some of this is irrelevant anyway, but we'll see what the response is, because Salty will respond. And then there's a declaration from her saying, from KJ, saying, I believe, I was and have been credited by other YouTube commentators as being the first to publicly report on Clark Swanson's October 2020 lawsuit filed by plaintiffs in this case on October 28th, 2020. Is that 6 times? Is it 6 times? It's in here again that she broke the story, and I feel like they're missing the point. The point is not that you broke the story. The point is the statements made from the story. Like, the point is saying in the lawsuit, it says Clark Swanson used his banking relationships. And then this complaint alleges that she said they had no credit, they had no money, they had no bank accounts, they were broke. It's not about breaking the story. I feel like they're not seeing what's in the complaint. It just doesn't attach. She talks about the business, talks about being a resident. I did not conduct any research in Washington state or rely on any Washington residents as sources in relation to the publications on which the lawsuit is based. We're talking about those publications now, which is good. I accessed all of these materials for the stories, which were in public records in different states, not Washington, from Minnesota using the internet. I did not in any way target these publications at Washington state. My publications are aimed at a general national and international audience on the internet. My understanding was that Tati and James Westbrook resided in Los Angeles, California, at least until Miss Westbrook publicly announced that she had moved to Seattle in December 2019. Even after that, however, Miss Westbrook posted videos to YouTube that indicated she had not moved to Seattle even by March 2020. Okay. But my understanding was that they lived in Los Angeles until she publicly announced that she had moved to Seattle until December 2019. There are still videos, like if the entire motion that's the business partner one. Hold on, let me pull up the other one. But if the entire motion on jurisdiction is based on the fact that they lived in LA, and you're saying in your sworn declaration that you knew that they moved, then doesn't that just prove the point that you knew that they moved? Because there's videos. I'm just going to pull up the defamation suit one more time because there's videos into 2020, and that's enough that there's videos into 2020. So let me pull up the business partner suit one last time, and then I'm going to answer questions. So I feel like the jurisdictional stuff is not going to be well taken based on that declaration. So getting to this complaint, there are videos from, let's go to where December would be. Oh, no, they're alleged after May 11th, 2019. So May 2019 to, okay, May, June, November, and then we get into 2020. So even if we take the, I didn't know they moved until December 2019. Even if we take that, there are still videos being made into 2020, which still brings jurisdiction, I think, back into Washington. So this whole thing feels like it's a jurisdictional argument, but then the declaration says that they moved in December 2019. And I imagine that in the response, Tati's side, who said in the complaint that she lived in Washington in 2018 and permanently domiciled there in 2019, I imagine that they'll just bring in the proof that she permanently domiciled there since they alluded to it in the complaint. So I think they'll also probably bring in the videos where she said she was looking into Tati's background and birth certificate because that would have had to have happened in Washington. I'm going to look at some of your questions and comments, and then we are going to pop off. That is my initial response is there's a lot of like YouTuber tea in here. There's a lot of shade thrown at Tati over Bi Sister. We've talked on this channel a lot about Bi Sister. You know that I'm not a fan of the Bi Sister video and what went down with that. I didn't like it. But we're not trying Tati's character to dismiss the complaint. Like, that can come up later when she testifies. That stuff can be made relevant, but it doesn't have space as it goes to jurisdiction, and it doesn't fit as it goes to the like 12b6, because with 12b6, it's just the complaint says this and that's not enough. And then as to jurisdiction, it's like, this is why there's not jurisdiction. So the other stuff is really like, Bi Sister sucked, Tati sucks. Okay, well, we know that Bi Sister sucked. Did we need to make that point? I don't know why we needed to make that point more. Does anyone else think her lawyer is new to the case because how they do not understand the vid KJ made breaking down the case isn't the problem? I don't know. The complaint I find to be really clear. So the complaint breaks down all of the different videos and the statements said in that videos. So I was expecting bombs to be dropped. I was waiting for like the mic drop, this is over. I don't see a lot of the points here being well taken. I also don't know which section under the federal rules that they're claiming. So I think there's some 12b6 stuff, which is unlikely. 12b6 is pretty hard to get it dismissed. It's like, even taking it all as true, there's nothing here, which is not what I see in the complaint. And then the jurisdictional stuff is addressed in the complaint. I can understand arguing it, but I don't think there's a complete lack of evidence that Tati lives in Washington. So what will happen from here is we will get the response. Again, this is a motion to dismiss. The things in it are allegations, but really the things in it are a recitation of Dramageddon. I think that's where we're at. So for the legal breakdown, I will sleep on this a little bit and be like, and try to parse it. I really wanted to see it's, again, I have to now guess at which section they're trying to put stuff under, because issue, rule, argument, conclusion, like legal writing is in a very specific format with issue, rule, argument, conclusion. So it's hard for me to try to now guess at what is I understand the issue, but what rule are we following? Because they skipped over which rule we're doing it. Is this a boilerplate response? Not really. It's it's not, because it doesn't follow that format. And you can do a boilerplate 12b6 saying there's not enough evidence here, it needs to be dismissed, but it wouldn't read like this. It wouldn't have the length of information in it. And I think that these exhibits are going to the jurisdictional motion, but that could have been brought as a motion to quash the subpoena. So I don't know why it wasn't. She had the chat open for less than 10 minutes. Oh, somebody's live. I'm sure. So, I mean, I'm sure there will be more Twitter stuff happening. This will come up on December 28th. I will do like a legal breakdown of it. Like, these are the rules. But the thing is with this, I have to attach the rules to it and try to parse again on another reading, which section of 12B I think they're going to. And then it will be some speculation on my part saying, I think they're getting at this. Do you expect Salty to comment on the response via Twitter, or is that inadvisable? His comments on Twitter are priceless. I don't think he'll make a comment on this on Twitter. Of course, I don't really know what he's going to do, but what I've seen from him is that when she says stuff that could be harmful to his case, he responds, but there wouldn't be a need to respond to this. They'll file a response in court to this. And what we'll probably get next is what we should get next, I think, would be KJ's response to the motion to not delete your shit is what I think we'll see next. So this is just, if the chat, don't get salty in the chat. Yeah. The motion to make it make sense. CC Tim, that's pretty funny. You're not wrong. I really do have to sit down and try to parse what we're trying to get at. KJ tweeted out a link to the video of the business partner lawsuit an hour ago. Oh, I mean, so she did, but it's just not about that. How much is this going to hurt her case that she's choosing to re-promote one of her Tati videos? I think at this point, the character stuff will come up. I said earlier today, judges and juries don't like hubris. So that kind of behavior will come up of, well, you didn't take this seriously and you just kept going. So it's just going to get messy. I find that juries don't tend to like that. So for me, legal strategy wise, if the legal strategy is, I'm a small channel, why would you even mess with me? This seems ridiculous. If that's the strategy, then continuing to poke the bear will, I think, negate that strategy in the eyes of a jury. Like, I'm just a small YouTuber, like, please leave me alone. You're a big channel. I think the continued behavior to poke the bear will let a jury go, no, this is a pattern. And part of this is going to be a pattern. And that comes into whether a jury will see this as a pattern of harassment for some of those allegations. So it will it will all come up. All of this behavior will come up. And I'm just a small YouTube channel, please don't pick on me. I don't know if it will play well with, they're never going to sue me. They're never going to want to sue me. I'm going to get to do discovery. And the other pokes that have continued on social, if she had stopped after this, it would be a lot easier for her attorneys to say, look, they filed this lawsuit to stop her from talking. She was doing her job. She had to shut down her channel. There was little she could report on. I think that's an easier argument to make to a jury for sympathy, truly. But that's case strategy, and it's not my case to try. That's when I think case strategy, that's kind of where my head's at. Let's see. I'm trying to get to the questions. I know there's a lot of them, and I'm going to try to get to a few more. Thanks for the lesson on what not to do in a response. Well, Layla, you're welcome. I mean, it's not a law school class, but someday, this will be a law school course on civil procedure, because it brings in the interest of pop culture and YouTubers and drama, and it brings that together with motions, to preserve, which don't come up all that often, but motions to preserve and behavior on Twitter and videos being deleted, like all of that comes together and makes it very interesting to talk about. So thank you. Let's see. She had 4 CNDs and she's tweeting videos that are about Tati. Yeah, it's just wasn't question from Stephanie. Wasn't it December 18th? The motion to not delete the motion to preserve evidence. I keep like with you guys, I call it the motion to not delete your shit, but the lawyerly title is like the motion to preserve evidence. That is set for December 18th. This motion is calendared, and I'll pull it up at the top. This motion is calendared for December 28th, which means the response to this should be due 10 or 11 days before that. So we'll get a response. We could get a response sooner. The Salty can respond whenever he wants. We should get a response from KJ's attorney, Michael, on, oh gosh, are both the attorneys in this case named Michael? That's going to get confusing. Well, we're just going to call Salty, and we'll just call this guy Other Mike. Other Mike will have to file his response to the motion to not delete shit soon, because that motion's coming up December 18th. And then this one is for December 18th. And then I put, is there 28 days notice or 21 days notice? That's my note to look into. I think it's 21 days notice. It could be 28 days notice. So that's what it is. We value all creators here. We have an awesome and respectful community. Let's keep building it. Thank you so much, Michael. That is true. Okay. So let's see what else. I know you guys showed me yesterday. I got snippets from the video she did where she said her attorneys were experts in defamation suits and federal procedure. So I was surprised to see that the rules of federal procedure weren't cited anywhere in the motion. I was surprised. We will see what happens after the motion to not delete her shit. Like we will see the court filings on what happens that day in court. Exactly. We should see her response to that motion. Sorry, I misread that. Will we see what happens after the motion to not delete your shit like we will see the filings here? It depends. A lot of judges will take things under submission and then issue a ruling. They don't always issue a ruling in court. If they issue a ruling in court, there will be a minute order. I covered some of the minute orders in the Britney Spears video I did breaking down the conservatorship, and that's a minute order is really a breakdown of what the judge decided that day. Sometimes those go up a few days later. Sometimes judges take things under submission and go, I'm going to need a minute to figure out what the fuck just happened. And so judges will take things under submission and issue rulings later. So the answer is annoyingly, it depends. The most lawyerly answer ever. I hate it depends, but is her legal strategy throw everything at the wall and see what sticks? It could be. We don't really know. I don't get a clear strategy. The strategy I get from what is said here is that the damages can't be parsed from what happened with the other creators and what happened with me. And so that's the direction I see them going in, but that's a motion for summary judgment and for trial. This was like a motion to dismiss is going to be jurisdiction, and there's no claims upon which relief can be granted. And that's not what I saw here. Thank you so much, Reality. I appreciate that. I'm so convinced KJ wrote this as a T script. At this point, I don't know. I see lawyers have to sign it. What's up, Octo? Lawyers have to sign it. So I would never, sorry. I had to switch water. My throat is getting really dry. Lawyers have to sign it. And so I can't imagine ever having a client write something. I have clients summarize things for me. Like, can you give me a summary of everything that happened? And then I'll ask them questions about it. But I've never had a client write stuff. So I don't know if that's what's going to happen. Can you have a court-appointed lawyer for a case like this? No, it's a civil matter. You are on your own in a civil matter. That constitutional right extends to criminal matters. Just curious, did this actually answer any of the accusations made in the defamation lawsuit? No. And it wasn't meant to. It's not an answer. It is a motion to dismiss. So the difficulty I'm having with it on first look is that normally you get like issue rule. So the issue is there jurisdiction? The rule is 12B. Let me pull up which one is subject matter jurisdiction and which one's personal jurisdiction. 12B2, lack of personal jurisdiction. And then it would say under 12B2, we have to prove this, and we prove this by this, and then all this other all this other stuff. That's the normal pattern you would see in legal writing. Is there jurisdiction? Or even if you're writing it argumentatively, there's not jurisdiction here, therefore the court must dismiss. The rule is under 12b-2. Under 12b-2, we have to prove this. We prove this by that. That's the pattern. So that's what I didn't see here, but it's not meant to be an answer to the complaint. The answer to the complaint will come down the road being, well, we didn't do the shit that you said we did. So we deny and reserve our rights. That will be the answer. But there can also be motions for summary judgment saying, we got this, boo. And then you file all your evidence and say, dismiss this shit. So that can happen. Guys, when I worked as a law clerk, the amount of motions for summary judgment that I had to read, and they would come in. And when I say the motions for summary judgment would come in boxes, they would come in boxes of documents. Boxes of documents. So, sorry. People are talking about her attorney. Let me see if I can get to a few more questions, and then it's 9:30 and I'm going to say goodbye. I think we're on sign off number 2. KJ said she's been working on the lawsuit to save money. I mean, I can see like flagging all the videos. In a case like this, I could see her flagging the videos and say, these are the things I relied on when I reported. I can absolutely see that happening and not being improper to do so, being like, I'm the one who's intimately familiar with what happened. So here are the videos and here's the list of them. Like, don't spend your money to go find them. Let me show you where everything I relied on is. I can see that for sure happening and being appropriate, but I wouldn't write my own, and I can't imagine that she would have. So answer a few more questions. It's a lot in here, you guys. It's just a lot. It's just a lot. And it's going to take time for me to parse which rules we're getting to because it's just not in here. The mods are awesome. So thank you. Oh, 50 Feisty. I'm dying to see what you said. I think KJ is going to be way in over her head and had no idea how bad this is going to be for her. As an attorney, I can say that with a great deal of conviction. I would, if you ever want to DM me your thoughts about this, I'm trying to be fair. I want to be fair. I want to see the points well taken. I think there can be points taken as to damages. It's just not the place in the motion to dismiss, and the reliance on what happened in Carmageddon and Dramageddon doesn't go to jurisdiction, and this is mostly a jurisdictional motion. So that's where I'm left a bit confused. The calling Jeffree Star with 2 R's the same way it is in the Swanson suit also confuses me. I need to know. Sorry, I'm tired. So could this request for dismissal just be a way for them to buy time while they hunt for anything that might help? It would be an improper use to do so. But again, motions to dismiss and motions for jurisdiction normally come up at the beginning of a case. They have to. Like if you do anything else first, the jurisdictional stuff is waived. So you shouldn't be using motions to buy time, and motions can be dismissed for that. I think they really want a jurisdictional motion, and I think that's appropriate. I don't know if it will fly based on this. Scarlett, thank you. You've reminded me that it's Twinkle Twinkle Time. It is just about Twinkle Twinkle Time. I am going to do a legal breakdown here. I saw somebody say there's a lot of drama channels here. Please get a lot of drama channel and T channels are here. Please give them the advice they are looking for. I don't know what advice they are looking for. There's a lot here. It's pled kind of funny for me because it's not spotting the rules. There's a lot of tea that doesn't really relate directly to the complaint, but it seems that the direction this is going in is, yeah, but Carmageddon and Dramageddon caused all the problems, but that is the place for a motion for summary judgment, not a motion to dismiss. So I'm trying, you guys, to parse it. We'll do a legal breakdown of what some of this means. Is it going to get the case dismissed? Like hands down? Is there something in this where I went, that's the thing? No. Do I expect that in most motions to dismiss? No. Most of them tend to be procedural. Do I expect we'll see a response with regard to the jurisdictional elements? Yes. But I really do think that the when you sign off, we will spam twinkle twinkle, take a picture for the little guy. I will absolutely take a picture for him. I hear him outside the door waiting, which is late for him, so I definitely need to go. But I think that the admission in the sworn affidavit is the one that's going to be very, very interesting, because KJ acknowledges that she knew that they moved to Washington. So they're arguing jurisdiction, but in her sworn declaration, she said she was the first one to break the story and that everybody needed to give her credit. That was in there too. But she also said that, this is the last time I'm pulling it up, because this was the thing I was most surprised about. Truly the thing I was most surprised about. And you guys, welcome that are channel members. We have our channel member live chat tomorrow, our channel member live stream, channel member only live stream tomorrow night at 7. But I really do think this statement will be taken by a judge. My understanding that Tati and James Westbrook lived in Los Angeles, California until she publicly announced she moved to Seattle in December 2019. I think there's enough videos made after December 2019 that the judge will look at that and say, thank you guys, that the judge will look at that and be like, right, but you knew that they moved, so everything is coming out. I really do. And then I think that we will need to see, and I will need to go back through Reddit and look at, not credited for other YouTubers. I need to go back through Reddit and look at where the videos about her searching up stuff on Tati, because that would be, if it's the background stuff, that would be stuff in Washington. And then I know there were videos where KJ talked about, and you guys are welcome to direct me to them. There are videos where KJ talked about the fact that they were moving and that she thought it was shady because she thought they were trying to avoid stuff going on in the business partner lawsuit. But even then, it acknowledges the moving. So it's like there's a motion on jurisdiction saying that they lived in LA and there's no cause for venue, but venue doesn't require a ton. So I think what a judge is going to find is that they live in Washington. So there's diversity jurisdiction here in Washington. That's kind of where I think this is going to go. We'll see. Salty will respond. Maybe we'll get something shady in a footnote. You know, you guys, we'll see what happens. I was looking for a shady footnote. I was like, where's a shady footnote? Instead, we got a Trisha Paytas video and PewDiePie and Keemstar. Who knew? That's what I wouldn't have expected. That's what I didn't see coming. I did not see Keemstar being relied on as a source. That's what it was. I did not see that coming. Accurate. Didn't see it coming. I will have a video with the legally things other than my initial opinions. I cannot wait to see how the community in the commentary space responds to all of the stuff that's gone on in the last few days. I'm very excited about it. On KJ's lawyer's website, it says his assistant is Kathy Swanson, could be related to Clark Swanson. What? I live. Would that be an issue? No, it wouldn't. I mean, it would. I would have to think on that. I don't think it would be an issue. Y'all, internet super sleuths of the world. Of the world. Wouldn't that be tea? So there's the thing. It said, tell the drama channels what they need. There's the thing. There's the thing. Is Kathy Swanson related to Clark Swanson? I don't know. There's the thing. All right, you guys, I have gone over. Thank you so much for respecting my family time. I adore all of you. I will see you tomorrow. I will probably see you on Twitter a little later tonight because I want to see what everybody else has to say about this case. I appreciate you. Thank you for being here. Members, I will see you on live stream tomorrow night. I will try to have a legal breakdown video up for you tomorrow. I have to match the rules to the sections of this document, and it's going to take me a minute. I appreciate you guys. Thank you for being here, and I will see you soon. Connect with me everywhere. I'm at the Emily D. Baker. The podcast is the Get Legit Law and Shit podcast. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube